Judge Reed.
Good morning.
Good morning, Your Honor.
So I looked at this and let me just double check something. I didn't see any objection.
I did file a responsive declaration objecting, and that was filed on the 15th.
Oh, I wasn't there when I looked at it. Look at that.
It's really short.
Counsel, Ms. Jeffers, you had filed this motion, so let me hear from you first.
Yes, I don't really have much to say, Your Honor. Obviously, I filed the judgment and sentence. Mr. Morgan is in prison for years at this point, and under RCW 2609-320, abatement is appropriate in this case. I believe at this time there's only 2 remaining minor children, so we would ask that the amount go down to $10 per the statute.
Give me just a second. Can you give me that site again on the statute? I want to take a quick look at that. I looked at it.
Yes, it is RCW 2609-320.
All right. So Ms. Bliss, I guess, have you looked at that statute?
Under 2B, it says that the payee or the department can rebut the presumption by demonstrating that the person required to pay support has possession of or access to income or assets available to continue to provide support as contained in my client's declaration. Mr. Morgan had substantial assets upon separation. Obviously, they're not in his current possession, but likely in the possession of his family members. My client argues that those could be liquidated to continue to pay support.
I guess the question on this is, do you have an objection to the abatement language being in the support order?
I don't have any objection to the language being included. Obviously, I think that was an update after the initial order was filed back in 2020. But I think reducing the support to the $10 a month is what the objection is.
Well, I'll authorize an amended order adding the language, or an order that does add the language to the order. I don't have any basis to not reduce it currently. I mean, I just have the response doesn't provide there probably needs to be a hearing on whether or not this actually is going to get reduced.
And Your Honor, I will indicate that the burden is on wife in this case to prove if she thinks they're substantial assets. I don't think that she's met that at this time. I would ask that it be abated to $10. I don't mind reserving the final determination for trial. But at this point, just saying he had assets at separation, which was years ago, it does not meet the burden. And so I would ask for abatement at this time.
Well, I think what I'm going to do is I'm going to authorize the abatement. That will be subject to review in the dissolution proceeding. If it turns out that there are significant assets, that would be could be backdated to today. But I think the statute's pretty clear, and I don't know that this declaration from Ms. Morgan is sufficient to overcome the presumption, although very well may be overcome during the course of the dissolution. So I'm going to authorize the abatement, again, subject to review in the dissolution proceeding.
Very good. Thank you, Judge.
I'm going to put that under 5 as the court orders. I'm going to just put subject to review to this date in dissolution proceeding. But I think the language in the statute seems pretty clear. So.
And Ms. Bliss, do you think we need a date for entry?
I think
those are going to be the only sections I'm changing.
I think he's entering it right now, but
yeah, I have an order, and I'm just adding that language to there.
Perfect.
So I'm adding your order, but I'm just adding that it's in the dissolution. If you come up with a back to this date, a reason why it shouldn't have been abated, that can be essentially done retroactively.
Thank you, Your Honor. Right. Thank you, Ms. Bliss.
Thank you.
This is a little, I was trying to sort this out. It looked like Judge Evans had heard this.
Your Honor, he did, and he set this over 1 week to allow Mr. Lopez the opportunity to file his reply. From Odyssey, it doesn't look like that occurred. We did provide a supplemental declaration based on some of the comments that were made at the last hearing.
Mr. Lopez, President.
Yes, Your Honor. I wasn't able to send those out, unfortunately.
All right. Well, when I reviewed through this, again, it wasn't real clear. It looked like, I'm not sure what Judge Evans was looking for. I looked through the motion and looked through the response. I don't know if anybody's planning on filing anything additional, but I guess I can proceed on what I have.
Yes, I'd prefer that, Your Honor. This is our third hearing. I don't think it necessarily needs to be in front of Judge Evans. We argued a little bit, and it ultimately just resulted in the set over today.
All right. So, Mr. Lopez, this was your motion. Did you have any comments you wanted to make in support of that?
Well, unfortunately my exhibits weren't sent out, but as long as you have my response, I'm totally okay with handling this matter today.
Okay. So do you have any comments you'd like to make in support of your motion? You're the one requesting this, so.
So basically, this is my second time finding Juanita in contempt. Our parenting plan is pretty basic. She is not following it at all when it comes to me being on having full access to doctors, his bank account. I call these places and they tell me that I have no right, they can't release any information to me.
Well, I have to object to that information wasn't contained within his record.
So you don't have that in a declaration, sir, and it would be hearsay from a statement like that.
In my response or my exhibits, I have a response from the bank from Red Canoe where my son's account is, and it says that I have no access.
Again, I have to object. This is the information that he was supposed to file and didn't.
Right. I don't have those exhibits, sir, so I can't.
That's all right.
Base this on that issue.
Sorry. Basically, what I'm here for today is to resolve the matter of not missing visitation with my son. I bring this motion in good faith. In our parenting plan, you know, my son's mother is supposed to work with me because when we made it, the original pickup time was 3 p.m. and I had recently, well, I've been working 12-hour shifts for the past 6 months. So during that time, it was kind of 8 hours here, 12 hours here, but we've been working for a steady 6-7 months, working 12 hours. So I work 6 to 6, and unfortunately, I don't have anybody to pick up my son. So that's why we made our parenting plan a little more flexible, where she's supposed to provide a third party or at least meet me halfway with given a good ahead of time notice. And Juanita does not at all meet me halfway in that matter. I've missed 3-4 visits the past 2 months, 3 months. And really, I'm just here today, Your Honor, to get help because I'm missing good quality time with my son. And my son has a sister and she's full-time in my life. My son is not full-time. They have a great relationship. And I'm really missing the bonding experience with my son because of these games that Juanita is playing.
All right. We're working off of the December 15th of 2022 order, correct?
Yes, Your Honor.
Okay. Okay. Well, let me hear from respondent.
Yes, Your Honor, Megan Gilmore on behalf of respondent and non-new moving party, namely Juanita Friend. My client simply isn't in contention in this case of the final parenting plan entered in December. I think it's very important to know that I think this is the second or third contempt that father has brought since we finalized this case that has been denied. My client shouldn't be forced to defend her rightful actions. And again, nothing has been done willfully or intentionally in violation of the order. First, regarding decision-making, as that was included within the motion, my client explains that she hasn't acted outside of the order. She applied for the child to be in preschool. She's on several wait lists. Once those, providers become available, my client will confer with father. If the parties can't agree at that point, then we will bring it back before the court as that's the rightful remedy. My client currently is on maternity leave and is providing education for the child while she's on leave. This child's meeting milestones. So frankly, there's just simply no contempt here as there's been no action. The child is school age, will likely go to the school district in which my client is located as she's the primary parent. But again, that's something that we will have to deal with down the line and come to an agreement or go before the court. So there's no contempt regarding decision making. I think that the larger issue is, yes, what father has mentioned within his dissertation of the contempt is the fact regarding visitation. My client continually is willing to provide to the child on Fridays at 3 p.m. However, father is wanting my client to constantly modify and work outside of the order. My client is willing to do so, but up to a point. She has an infant, she lives in Lewis County, and she shouldn't be constantly forced to modify the parenting plan on a weekly basis. I think that the parenting plan really contemplates this, and father was represented at the time this final parenting plan was entered, and if the court looks to this was drafted by father's attorney. If you go to the transportation language, it specifically contemplates that father does have a rotating work schedule and may not be available at 6 p.m., but it does carve out that he should be providing third-party transportation. We were last before the court on contempt. The court made it specifically that his father or his girlfriend can be available. As explained within my client's declaration and not refuted with any materials, father's living girlfriend, who he does have a child with, is in this, i.e. in a serious relation with, does not work. So she is available, but father's refusing to do the exchanges and wants to do it at 6 o'clock rather than 3 o'clock. As explained within my client's declaration on September 8th, she went to YMCA at 3 o'clock. She waited a substantial period of time. Father didn't come. The transportation language specifically says that the child shall be picked up and returned at designated times. My client, again, shouldn't be in a weekly situation where she's fighting with father. If you look to the text messages, not only is he asking to modify the schedule, but he's frankly being extremely nasty to my client and threatening her on a weekly basis. So he brings this action with unclean hands by not only violating the parenting plan regarding the provisions, but then frankly bringing contempt for language that's simply not in the order. There's no requirement that my client is working with him on a daily basis. She testifies that she frankly has, but on the September 8th date, she couldn't. So we asked the court to deny the contempt regarding visitation. My client provides information within our supplemental materials that the father does have access to all the information regarding the tribal. She not only has signed multiple releases, but we've now filed those releases, so he has access to this. We're simply asking for direction of the court that my client doesn't have to continue to go back before the court on orders to show cause of language that simply isn't in the parenting plan. Father needs to be picking the child up at Friday at 3 p.m. for his normal exchange. And again, if he's not available, there is remedies within his parenting plan, again, that was drafted by his attorney.
All right. One question, I guess, and I didn't hear a response on that. It was in the motion having to do with a bank account question.
So and that was something that we addressed, that we did talk about a little bit with Judge Evans. Excuse me, sorry, Aaron. There is a section under decision making that mother is to sign any documentation necessary so father can have access to the Cowlitz Indian tribe information. First, father is the tribal member. So my client doesn't believe that she could even deny this access, but once we realized that he was arguing access rather than the bank account at the last hearing, my client provided the supplemental materials and the release of information that shows that father has ability to get access to any information from the tribe.
Well, the question was raised something about a bank account. That's what I'm trying to understand.
Yeah.
I'm supposed to have full access to the bank account, and I do not, because I am the tribal member of my son, but she is the full custodian parent. So basically, she's able to make it to who calls and gets release of information. I can't get any information from my son from my own tribe. And Your Honor, my tribe is full of all the employees, is all my family, is all family, blood related. And they tell me that Juanita friend had specifically called and said that nor my
Okay,
son.
well, sir, I don't have a declaration from those folks, so
That's
those
all
are
right.
all hearsay statement. My question has to do with a bank account. It's got nothing to do with the tribe.
So
Unless it's-
basically, Juanita gives me statements of the bank account, but I'm not able to call. I'm not
Okay, well,
able to.
let me ask, where in the parenting plan does it talk about the bank account? That's what I'm trying to find.
Your Honor, I'm at work right now, so I'm sorry. I don't have my parenting plan in front of me.
Is there a section that has to do with the bank account specifically?
It says release. I'm not sure where, but it's somewhere in there. It says release of information. That I'm subject to all information.
Parenting plan contemplates that my client is supposed to sign any releases for the tribe. It requires her to continue to deposit the tribal funds into the bank account. There's no language that requires him to be on the account. That's basically what he's saying. I believe that's his argument.
Okay, because when I looked at the parenting plan, I didn't see any language that would put you on as a joint owner on the bank account. Well, sir, let me hear from your response to that.
Well, to start it off, like I said, I bring this motion in good faith. I do not harass Juanita Friend at all. Our conversation is directly through the parenting app. I do get frustrated because this is an ongoing thing for 3 years now, and it's very frustrating because there's two sides to this. I tell Juanita every time before Friday at the beginning of the week, hey, I'm working 12 hours again this whole week. I'm still working 12-hour shifts. I'm not able to make 3 p.m. None of my family will come for third party to pick up my son just due to the fact that there's been too many allegations. There's too much drama. My family will not involve themselves at all to pick up my son, but they are involved once I have my son. And to be honest, it's no one else's responsibility to pick up my son but my own. My girlfriend doesn't work, that's correct, but she's a full-time mother of our 1-year-old daughter. She's 13 months old, and she goes to college full-time. And that is also not her responsibility to pick up my son, but my own. And we are limited to one car right now, and the car is being driven by me to and from work. So I have no one to pick up my son on those Fridays. So I try to give a reasonable notice at the beginning of the week and say, hey, I will not be there. No one will be there at 3. I also ask her, hey, would you mind dropping him off at my house to my girlfriend? And she denies it. And she purposely goes to the YMCA where our pickup and drop off is just to deliver her end of the deal, saying that she showed up, that no one showed up. But Your Honor, she's doing that. I don't know why, because she's quite frankly wasting her own time doing that when I'm telling her, hey, no one's going to be there. Here are the options. Can you meet me after work at 6 when I'm off? Or can you drop my son off? I work full time, Your Honor. I can't leave my job. I don't even have breaks on my job. Like, I work. And it's like I said, it's just no one's responsibility. It's my responsibility to pick up my son. I don't harass Juanita. I'm quite frankly very much done with communicating with her. I just want a simple pick up and drop off is all I want. I don't feel I need to pay any attorney fees today. I brought this motion self-represented because it is a simple matter. I speak for myself. Like I said, I bring this in good faith, Your Honor. That's all I have to say.
Your Honor, if I may, real quick.
Sure.
The transportation language specifically says that Longview YMCA is supposed to be the exchange location, simply because under Section 14, there's restraints because father didn't want my client coming to the home. So that's the basis for YMCA. I just want to provide that clarification.
Right. Well, in looking through your parenting plan and looking through the different declarations that are filed, it looks like there's been releases of information. There may be some other things going on, but I don't have that information in front of me, so I'm not going to make a finding of contempt on the release of information issue. The bank account, there's no language that I can find in the parenting plan that requires the father to be a joint owner or be listed on the bank account. And it sounds like, I mean, there was a copy of, or a snapshot of a statement that was sent that would seem to comply with the sharing of information. The transportation issue is, and these are always challenging when people have so you set up these very specific parenting plans, and then circumstances change, because the court is essentially stuck with enforcing the document that's in front of me, the actual listing of dimes and dates and places and that sort of thing. That if the two of you agree to something in writing or through the parenting app that says you're going to do something else specifically, and then that's not followed through, and I have evidence of that, then I would maybe have grounds for contempt. But there's no requirement that there be a change in any of this unless you come back to court and get an actual order that changes the parenting plan. So you had indicated yourself, sir, that it's up to you to pick the child up or make arrangements to pick the child up. It sounds like at the last hearing there was some additional folks that were specifically approved. When I look at your parenting plan, it talks about child can be picked up by third parties. By your designee. It doesn't specifically, other than a restriction on Candida Sanchez, it doesn't look like there's a restriction on who does that. Well, I guess there is. There's a section here that talks about a designee who's known to them and the other parent. But it seems to me if you may need to locate somebody else under your parenting plan to do the transportation unless there's an agreement to do it at a time when you're not working. So absent an agreement that's been violated or a specific violation of the parenting plan, I don't have a basis to find contempt. So I'm not going to do that. So, I mean, your options at this point, sir, are to either come to some agreement and have that in writing, or to come back to court to modify this based on your job situation, which very well may be sufficient to look at some minor modifications at times, but I can't find contempt based on what I have in front of me. So I'm going to decline your motion.
Does your honor want to enter a bench order? Do you want me to prepare that order? What would you prefer?
I have an order, but it's not the one I would use. So this is a proposal that he'd provided, which has got all the findings in it. But if I do a bench order, it's just going to be the motion's denied at this point.
I prefer, I'll just prepare it just so that we have some clear language regarding the bank account, so we don't have ongoing issues with that. Is the court making an order on fees? I'm looking at my client statement. She's paid quite a bit.
Well, at this juncture, I'm going to order 500 in fees, not 1,000.
Okay.
Again, this is what you're going to need to do, sir. Is you may need to get some legal advice on how to address this so you can get this changed so it works with your schedule. But bringing contempt on something that is not in contempt is problematic for the court. So, as far as presentation, if it's agreed, just go ahead and submit it ex parte. If it's not, pretty much I can put it on for maybe the 8th at 8:45, which is a week from Friday.
I can do that. I just want to let the court know that I will be in Clark, but I should be able to balance both.
Okay. I mean, you can note it up if you can't agree too. It's up to you.
I prefer to just put it on the calendar so you don't have to worry about it. Let's do the 8th and then I will figure it all out.
Okay. So, Mr. Lopez, she's going to prepare up an order from today, send it to you for your approval. If it looks correct, you can sign it or let her know that you're in agreement with that. If you're not, then show up at 8 o'clock via Zoom on my 8:45 a.m. presentation docket. Okay?
All right, thank you.
You're welcome. So I did have a chance to review this. This was also a little confusing. It looks like Judge Evans heard something on this on the 31st.
That's correct. At that time, Mr. Bondurant had requested a continuance so that he could provide reply documentation. That was granted. There were some other rulings that were made by Judge Evans at that time. And one of which was that Mr. Bondurant was to file responsive documentation by November 14th. And so we had filed our motion for default. He was served with that on November 7th. He has not filed a response to the petition, so we're asking that the court enter an order of default. It's been 47 days since he was served in this action, and the court, as indicated on October 31, advised him that he needed to file responsive pleadings by November 14. If you go back and look at the
well, I'm looking at the clerk's notes and it doesn't talk, it talks about some, I mean, he filed the responsive documents on the 13th. It's not a formal answer, but he filed a responsive document, which is what that seems. So I'm going to defer on the default issue to Judge Evans. I can set that over. I don't know what he specifically ordered because it's not, I mean, it says to me.
Well, at this point, I've properly served him with a motion for default. He's had
And
3
I'm
weeks
denying the
notice.
motion based on the fact he filed a response. It's not in the proper form, but it's a response to the petition essentially. He needs to file an answer. I can give him a week to do that, a specific answer as opposed to the response that was filed on the 13th.
Will the court set that for sure that motion over to December 5th then?
I certainly can. So, Mr. Bondurant, I want you to understand what that means is there's a document called an answer that you need to file, which is different than what you did file. You filed the proposed parenting plan, you filed the declaration responding to all of these things that are in here. I don't know what Judge Evans specifically said because I don't have that in front of me, but it looks like he told you to file something on by the 14th, and you filed on the 13th. So you're going to have 1 week over to next Tuesday, the 5th of December, to have an answer filed. It's a form. You can get it off the court website, the state court website. All right.
Yes, Your Honor.
If not, you'll likely be found in default, which severely limits your ability to participate in the proceedings.
Okay, and Your Honor, I do have one small issue here. Is I start work on the 5th, and I have to have almost a month of uninterrupted work between 7 and 3 o'clock. So, I mean, on one hand, I'm being asked that I need to do this and I need to be able to do that, and then I'm having to go to all these court cases. I was unaware of this form. I don't recall Mr. Evans specifically providing that. I'm not an attorney, so unfortunately, I don't know the ins and the outs. I know that I met the deadline for what I thought that I needed to provide. I obviously don't want to drag this out. However, I do have a request that basically that I would need the month of December to push these things out. I already don't have visitation. I already don't have contact. So I don't see where the harm in pushing that out an extra month would be. That protection order doesn't end all the way until August.
Well, he doesn't need to appear on the 5th if he's complied.
Right. The issue really is you need to file the document. The form's available. And the reason I'm setting it over a week is, in fact, in part because you're self-represented. I want to giving you the opportunity to file the correct form. I'm not going to find a default based on you filing the wrong form. So you'll need to get that, download it, answer the petition, and get it filed. You don't have to be here next week if you don't want to, because unless we set some other things over. So, and I guess
I could file that, Your Honor.
All right, so you get that done. We could address the other matters that are before the court. One is an adequate cause request.
And I do have a preliminary request as well that was outlined in my client's reply declaration. Mr. Bondurant's responsive declaration, which is clerk's paper 50, I'm sorry, clerk's paper 81, has as exhibit 1 an excerpt from the sealed portion of the prior guardian ad litem report. I think it's improper to put any portion of the sealed guardian ad litem report into the public file. In addition, Exhibit B is documentation from Washington State Support Registry that includes the party's confidential 4D number. And that would essentially be treated like a social security number and the like. That should not be filed in the public file. So I'm asking that clerk's paper 81 in its entirety be filed under seal, and that a redacted copy of clerk's paper 81 be refiled, redacting those 2 exhibits, which is consistent with the information that the clerk provided at our last family law brown bag hearing.
Your Honor, the exhibit that I did put with the guardian ad litem report has absolutely no I don't understand who it would hurt to not be under seal. It really only mentions myself and something very sensitive to me. So for that to need to be under seal, I don't believe. Also that that ID number is also something that I could obviously refile and black out the ID number. I was not aware of that. But I mean, it does seem kind of silly. There's not much information that can be gained from that ID number. Anybody can call up underneath my name or anybody's and get that ID number if they wanted to.
I think that that's an inaccurate statement. That is a confidential number specific to DCS.
I don't know if it is or not, frankly. those get filed all the time. I don't know if they're confidential normally. But the other document, if that's from the confidential portion of the JL report, that should be filed under seal. So since we're going to be doing all of that, I'll order that all of that both of those be filed under seal.
That clerk's paper 81 be filed under seal, and then we'll file
Well, just the
everything.
exhibits.
They can't split it up. It has to be the whole document. That was the purpose of the training that we had on Thursday.
Okay, I apparently wasn't at that training. So well, I guess what you'll need to do then is file that under seal and then file the declaration referencing the exhibits that are under seal, because the declaration itself wouldn't be sealed.
So we'd have to file the whole clerk's paper 81 under seal, and then we would have to refile the 81 with A and B redacted from that into the public file. I'm assuming the clerk can maybe chime in.
Correct. We would likely just file it as like 81.1 or reference it later in the case.
Well, I'll order that we comply with whatever the clerk's rules are with regards to confidential sealing and how that gets accomplished. You'll need to work with the clerk's office to do that.
All right, so then that brings us to my client's request for an adequate cause finding and temporary orders.
Right. On the adequate cause, I'm not sure if you're objecting to that, sir. This is simply the threshold finding of the court to determine whether or not it can actually review the parenting plan and that sort of thing. Seems to me that's met, but I don't know if you have an argument against that. I didn't see one.
In terms of her proposed temporary plan for the child?
It's meeting the threshold for the court to be able to take a look at the parenting plan, to adjust the parenting plan, that sort of thing.
No, I don't disagree.
Okay, so I'm going to enter that order. That seemed appropriate, but I wanted to I'm sorry, Your Honor, I do have a quick question. I know that Judge Evans required me to meet a deadline. I don't know if that was me needed to meet a deadline or both me and Tristan's attorney need to meet a deadline on the 14th. But in her response that went beyond the deadline on the 14th, she brought in different exhibits that were unrelated to my response at all. And I feel like that should have been a declaration that should have been presented prior to the deadline.
So I didn't have a deadline by the 14th. Our deadline would have been a week ago, which we met. My client's reply documentation was filed on November 16th. It was in response to the allegations that he was making relative to his the claims that he was not involved in counseling decisions for Ellie early on back in, I think it was 2020. The claims that he does not have the ability to provide the financial support, and in response to his allegations that he shouldn't be required to participate in the services that we are requesting and the findings that we're asking against him. So I think that is strictly in response to his information. It's also documentation that's in another court matter that Mr. Bondurant is involved in as far as his dissolution.
Okay, well, it seems to me this is a case where, and we may want to wait until we see if there's a default issue addressed. My thought would be this is a case where we probably need a guardian ad litem appointed to look into the matter.
That was another area that I'm confused on, Your Honor, because there is a guardian ad litem have been in another case for my other 3 children that has been appointed. I do recall Ms. McLean
So is the court going to, can I ask for a point of order at this point? Is the court, are you going to hear the motion, or from what you just indicated, you question whether or not we should be proceeding as far as the concern relative to the default?
There's a couple of things. I'm hearing the motion, but I guess my question is, do you want to wait until an issue addressing the default is addressed?
I mean,
I think as far as the appointment of a guardian ad litem, yes, I think that we should
Okay.
wait on that.
Okay, so we'll set that over. As far as your request on temporary orders, that's, I think, what we have left. Am I not mistaken?
That's correct.
Okay.
So with that, this matter all started with a protection order that was entered on September 12th of 2023 that protects Ellie from Mr. Bondurant. Ellie is currently 14 years old, and she has been exposed to domestic violence by Mr. Bondurant within his household and directed towards Ellie. Uh, Obviously, 14 is an impressionable age, and Mr. Bondurant should be modeling the type of role model that he wants his daughter to experience on her own in the future. Instead, Mr. Bondurant has been engaging in domestic violence, substance abuse, primarily alcohol, untreated mental health, and overall instability as it relates to his housing, his employment, and the like. Findings from the contested protection order hearing found that Mr. Bondurant is a perpetrator of violence within his household and that Ellie has experienced anxiety, apprehension, worry, and prepared a safety plan with her mental health provider relative to what she was experiencing during visits with Mr. Bondurant. During the most recent domestic violence incident, Ellie was directly involved, and Mr. Bondurant interfered with what he believed was Ellie's attempt to call the police as directed by her stepmother, Chelsea, when she, in fact, was too scared to call the police and had actually reached out to Ms. Peterson, her mother, by text. Ellie has disclosed to her counselor about struggling with her father's behavior, and this has been going on for years. Ellie has described her relationship with Mr. Bondurant as negative, poor, and non-existent. And Ellie's relationship appears to be tied more with her stepmother and her half-siblings, which actually is acknowledged by Mr. Bondurant. When Mr. Bondurant was removed from his residence with Chelsea earlier this year, I believe that was March or April of this year. At that time, he was not exercising visitation with Ellie. Ellie was actually going over and exercising visitation with Chelsea and her half siblings. So there's been protracted periods of time when Mr. Bondurant has not been exercising visitation. He did not exercise his summer visitation, and Ellie has continued to struggle. Mr. Bondurant claims in his reply declaration that he was not advised when Ellie was first engaged in counseling. Ms. Peterson provides to you as attached Exhibit A to her responsive declaration filed on November 16th, the text message communication between the two of them in October of 2020, where they specifically discussed counseling, and he was all for it. Now he attempts to suggest the sufficiency of the counseling is inappropriate because she's had intermittent periods where she hasn't been in counseling. Obviously, a counselor can't continue services if there's nothing that needs to be worked on, and mental health is a progress in motion. When the symptomology decreases, then typically counseling decreases. When the symptomology comes back around or increases, then counseling increases, and that's exactly what Ellie has experienced. There is nothing nefarious in providing Ellie with outside mental health support, particularly when she's experiencing the disturbance within her father's household. And to be quite honest, these kids have weathered a lot over the last couple of years. And for a parent to not take into consideration a child's mental health when they're reaching out to a parent for help would be not in the child's best interest. And if we were in that position today, I suspect that Mr. Bondurant would be making the other argument that somehow Ms. Peterson would have been neglectful had she not been meeting Ellie's needs. Parents need to take a child's mental health seriously, just as Mr. Bondurant needs to take his significant history and ongoing mental health issues seriously. So our position is that it is appropriate for Ellie to continue in counseling, and it's instructional, the fact that she has in fact had to enter into a safety plan for how to deal with her father. I think that that is information that is important for this court to be aware of. It's also concerning that following the entry of the protection order earlier this year, or I guess it'd be a couple months ago now, that at that time, Mr. Bondurant was ordered to participate in a hair follicle. He made a claim in court, he was on Zoom, that he was not in the local area, when in fact, my client recognized his location and he was in the local area, and he put off participating in the hair follicle. So that makes us question the veracity as far as whether or not he had done something to alter that test result. The other concern is that most recently, Mr. Bondurant, again, our perception is that in violation of the protection order, has attempted to friend Ellie on TikTok when he's to have no contact with her. Ellie did not accept his friend request, but we did again provide that documentation attached to my client's reply declaration. Mr. Bondurant does not have stable housing. He has not had stable housing since his separation from his wife earlier this year. He is not in mental health counseling, despite an involuntary commitment for a suicide attempt in 2018. And while he claims he's got a job, and while his financial declaration that he filed in his divorce action suggests that he had a job up through April of 2023, there is no financial documentation that he submitted and no disclosure as to what his employment has been. Mr. Bondurant's active case with his wife, Chelsea, it is accurate that there is a guardian ad litem that's been appointed in that action. There's also been a temporary parenting plan entered in that action here in Cowlitz County Superior Court. We provided that at my client's exhibit, I believe it's Exhibit C to her reply declaration. That was filed on September 7th. That order makes specific 191 findings against Mr. Bondurant, including domestic violence, assault, and emotional or physical problems that interfere with his ability to parent. So those are already findings that this court has made, as well as coupled with the findings that were included in the protection order. Mr. Bondurant has acknowledged that he has emotional problems, and at our last hearing, he did agree to participate in a mental health evaluation. It's notable that that was actually ordered in his dissolution case by Commissioner Carmi. So the grand gesture of agreeing to participate in that was something that this court had already ordered in another case. And apparently there was a discussion because the order also indicates that that could be correlated with whatever is ordered here. So Judge Evans, at our last hearing, ordered Mr. Bondurant to disclose who the mental health provider was so that my client could provide collateral input. He did provide that information to my office. My client did talk to a Mr. Dillagrange at Core Health on November 8th. I don't know the qualifications of Mr. Dillagrange. As you can see from our proposed parenting plan, the request is, and this is at paragraph at paragraph 4, B1, we're asking that Mr. Bondurant, given his long history of mental health instability, that he participate in a psychological evaluation with parental risk components. Mr. Bondurant, as indicated, previously had a suicide attempt. He has been involuntarily committed for a period of time as a result of that. He has continued to engage in substance abuse. So the concern is with reference to a dual diagnosis. And he's continued to engage in inappropriate domestically violent charged behavior in front of all of his children. So the reality is that we think that psychological evaluation with parental risk components will provide more information to the court rather than simply a mental health evaluation. So we're asking the court to order that. At this time, we have not received any follow-up information from Mr. Dillagrange. Mr. Bondurant has not provided any of that, and I've not seen any of that. I noted that when I was making my, I'm sorry?
I said I'm under the impression it's your responsibility to reach out to Core Health for that information. That's the idea of the release of information.
Okay, I don't believe that I've received a release of information. I'm not aware of that.
I sent you, I
I'm-
sent you the information that there was a release of information provided to you. Actually, not to you, to Tristan, which is what, by at the court's request. And it was something that I
So at this
volunteered
point, this
for.
is
That was
not an
not ordered.
objection, Your Honor. And
Hold on, sir. Let me just listen to what the argument is, and I'll hear from you.
Okay.
so I would note that during my argument, of course, he's raising his hand about the suggestion that he's in mental health counseling. That's my assumption as to why he was shaking his head and raising his hand. The issue is that we have no documentation or information that supports that he's involved in any type of services at this juncture. Currently, with the no contact protection order, we are also asking that the court enter a restraining order in this case, enter our proposed parenting plan that provides for no contact. His daughter has expressed being scared of him, being fearful of him. This is not a one-off. This has been going on, and it's outlined within the counseling records that have been provided for a protracted period of time. This is a gentleman who has issues that he needs to address. So we're asking that the court adopt our proposed parenting plan with the 191 factors that include the domestic violence, neglect, emotional or physical problems, substance abuse, and use of conflict. Outlined within my client's declaration were the issues relative to the substance abuse and how Mr. Bondurant often consumes alcohol the night of the incident, where I guess, Your Honor, I would just make a note that it appears that Mr. Bondurant is vaping during our hearing. I don't think.
I'm not watching this. I'm listening to you, Counselor, but sir, you shouldn't be consuming anything while we're talking. Go ahead.
I apologize.
So in any event, my client outlined in her declaration the issues regarding the substance abuse, the incident with him demanding to drive intoxicated with Ellie and his oldest daughter, and Chelsea stepping in to prohibit that from occurring. His alcohol consumption and the domestic violence that occurred that directly preceded our protection order. And again, this is a long protracted issue. So we are asking that the court not only require the psychological evaluation with parental risk components, but also domestic violence evaluation and a substance abuse evaluation. Those should all include collateral input. Those should all be at his expense. Mr. Bondurant is here with unclean hands. He is nearly $10,000 delinquent in child support to my client. He has outstanding judgments against him from the prior matter in 2020 in this case, where he was ordered to pay $1,500 towards my client's attorney's fees. He's made no payments towards that obligation. As I outlined, his financial declaration suggests that he had a gross income of $5,280 per month. And that, again, that's filed as the attachment to my client's declaration. So we're asking that the court enter the orders that we have requested. We are asking for a contribution towards my client's attorney's fees in the amount of $2,500. And then I guess we're setting over the appointment of the guardian ad litem to next week.
Mr. Bondurant, did you have any response to those requests?
Well, I mean, a couple things. I'll just touch base on a few of the things that were asked of me. For one, I find it highly stressful that somebody can recognize where I'm at when I'm sitting in a vehicle during a Zoom call. To suggest, which I was, I might add, in a vehicle during that Zoom call. I do recall exactly where I was. And I did, within 24 hours, take a hair follicle test, and everything came back negative. Miss McLean has made every attempt. I mean, it is her job, and that's what she's paid to do, is to make every attempt to outline things that are just completely inaccurate information. I do not consume alcohol, or have any sort of issues with substance abuse problems, and that includes alcohol. That can show in the test, and that included alcohol as well. And I also included in my declaration that I'd have absolutely no problem whatsoever taking a hair follicle test at the expense of the petitioner. Because if it is a negative test, which it will be, I don't feel like I should be financially responsible for it. And I know that it will be. So that's not an issue. In her initial request, she also requested a mental health evaluation. Now, because she doesn't like the findings of that request, she now wants to up it to a psychologist and suggest that that person is incapable of doing their job and providing them her the information that she wants. So basically, what we're going to keep doing is we're going to keep fishing for and fishing for and fishing for until we find a psychologist that's going to sit here and say that there's something wrong that there's not. I've undergone the mental health evaluation. I released the information. I did that voluntarily. I was not ordered by the courts at that point. It was something that I had already started to do. And yes, it was something that I knew that might be a recommendation or that it was going to be requested of me. And so I jumped on it before it was even brought to the attention of the courts. In terms of the domestic violence issues, they communicate about how there is a long-standing domestic issue. The last known time that Mrs. Peterson has filed any sort of petition or claim or change or modification of any kind is piggybacking off of another case, which is with my wife, and utilizing a allegation of domestic violence, one instance, and that instance is still under scrutiny. It's something that I'm still fighting. It was a dismissed case. It was then reopened, which I find to be extremely concerning, considering it was opened 3 months later in the middle of a custody case. So I can only imagine who would have pushed the issue to have that reopened. Okay, that is the one issue. From a financial perspective, she mentions there being a judgment from a lawyer for lawyer fees. I bought a house in 2020, and I don't know, I'd assume that most of you guys understand that if there was a judgment in place, it would have been required to be paid in order for me to have to buy that house, to be able to get a loan. And I paid, and we can look back at court records, I can provide them, that I paid $20,000 that year in judgments that were sitting at Cowlitz County Courthouse for things that I had unpaid. So if that was among them, it would have also been paid. Child support was something that, again, that I do have documentation that the court that it was child support cases was opened and closed multiple times. And that is where the negative balance comes from. I would have a zero balance. Then they would reopen the case and go back all the way back to the time that Ellie was 4 years old when there was no child support there. And that's where all that is. I am completely up to date over the last 5 years on child support. And I had concurrent payments for at least 4 years, at least, with maybe a small gap of a month or two. Even during COVID, I was on unemployment, and I was being charged child support out of those checks. That is the only instance. The issue with in regards to the social media thing in regards to Ellie, I don't recall following on TikTok. I very rarely use TikTok, but when I do, if I do remember, my child was on there. I'm not even smart enough to figure out how to block people. But I do know that on our order of protection, it does mention, and I had to go back and I had to look at another order to kind of compare and contrast here. I do believe that falls under the stalking clause on that, and that mentions social media and other forms. So if that was the case, I do believe that maybe a new order would need to be put in place where that stalking would need to be checkmarked because it is in another case also. In regards to Ellie's counseling, she mentions that in my declaration, in hers, she mentions that she started counseling in 2020, but there was no instance where Ellie had or Tristan had ever brought to my attention that I was the root cause of her counseling. It was that she needed counseling. So from 2020 on, according to Ms. McLean, she should have been undergoing counseling, which she wasn't. And in my declaration, I point out to the fact in her own declaration, in her own exhibits, shows that in those counseling reports that she was intermittently showing up, and she conveniently shows up 3 days after the allegation. And another issue being is that she's going to a very biased facility through the tribe. I was with Tristan for a year or so. I'm aware of how that place works. They protect their own. I would say that it's a very, very biased assessment. If anything, if she's going to challenge my mental health, I would 100% challenge that Ellie needs to see a mental health counselor from a different facility. And that's where I'm at. I've fulfilled every obligation to the courts thus far.
All right. Thank you, sir. Ms. McLean?
Well, obviously, Ellie's been going to the same counselor for the last 3 years. So obviously wanting to have a continuity and contact, and Mr. Bondurant didn't raise any issues until today relative to Ellie's counseling. In regards to, and I'm not sure what his basis of knowledge is about a biased facility. There's nothing in his declaration that supports that. Nothing in his argument. They provide mental health services to our community, and they do a good job at that. In regards to his attempt to walk around the TikTok, I think that that's a very concerning discussion that he tried to engage in. The court order, the protection order, clearly says he's to have no contact, and no contact is no contact. So it sounds to me that he has engaged in attempting to contact her in violation of that order.
I clearly said that I don't recall that happening. Sorry.
Sure. Just thank you.
So we do believe, and if you go back and look at my client's initial filing, all along we've been requesting a psychological evaluation. Mr. Bondurant at the last hearing offered up that he was already participating in a mental health evaluation. Judge Evans indicated that that needed to include collateral input from my client. But he set over all of the motions for today's hearing. And we do believe, given the long history here, that a psychological evaluation with parental risk components is appropriate.
May I speak, Your Honor?
Only with regards to that last comment.
Okay.
Not the whole case, just a response.
Oh, no, absolutely. So I said that I don't recall that. Here's another issue that, and I recently decided that I was going to change my separated wife.
This is exceeding.
This is purely responding to what you just talked about.
This is.
Okay, well, I'll hear it.
Okay. Those passwords and those logins have stayed the same for years. So people have access to those social medias. I've had absolutely zero contact. That is their only instance that they say that I violated. I don't recall in any way, shape, or form following my child on TikTok. I have followed this to a T. I have done every obligation to a T, including we're talking about this mental health evaluation, Your Honor. Okay. Again, she's referencing the fact that, yes, I identified the fact that I was going to be required, more likely than not, a mental health evaluation. I'm being docked for that. Yes, I proactively involved myself in the mental health evaluation prior to it being ordered. Yes. Had I done it prior to the incident? No. But clearly, I'm in court, Your Honor. Clearly, I have no access to my children. And clearly, I'm looking for a pathway to get those children back. Ms. McLean has absolutely no interest in me having my child back. I provided a proposal that literally gave the child
I'm going to object to
everything.
any
Sir, you're getting outside of your specific response.
Okay, I'm done.
Okay.
The only comment that I would make is that he does not deny.
Right, well, I've heard from everybody. So.
All right.
So, looking at the temporary orders, first off, on the parenting plan, I think I'm going to defer on that until after we see if there's a guardian ad litem, because there are significant requests that are contested based on the responsive parenting plan. There's already a request or an order. Looks like it was signed by Judge or Commissioner Carmi on 1025 for mental health evaluation. I think we start there. We'll see.
That's not in this case.
I understand that, but that also it references this case.
It does.
So I'm not going to order two different evaluations until we see if that's necessary. If there's a default entered, we don't need anything. If there isn't a default entered, then we probably need a guardian ad litem to look into the case and make some recommendations as to the specifics of evaluations if they're above and beyond what's already been ordered. As far as the no contact order, there's already a no contact order in place. And that's valid through, if I recall, I had that here. That's for a year. So that's in place through September of next year, correct?
September 11th, yes.
Right. So there's currently no access whatsoever under that order.
My request was just simply to make sure that we had a similar order here, because the expectation is that this is the case where all of this is going to be handled eventually.
I'm just looking at comparing the two orders. So these have different provisions. Was there a different language in your proposed order than what's in the protection order?
Because the restraining order language is different than the protection order. And the parenting plan provides for the no contact. So
The parenting plan provides for no contact.
yeah, our proposed parenting plan at paragraph 4 provides for the no contact language. The restraining order, the provisions that are adopted under that are the do not disturb, which is comparable to, I guess I would argue that's comparable to the no harm. The stay away is dovetailing off of part of that no contact. And again, the no hurt or threaten is part of the no harm. Oh, and then the not contact, I'm sorry, the stay away is comparable to D, which is the exclude stay away. But your
parenting plan, it just says no contact with child, correct?
Correct. Yes. So if you take a look at paragraph 4A1, no contact with the child. And then the restraining order provides for he's not to go to her home, he's not to go to her school, he's not to go to her daycare vehicle, although technically her vehicle, but her mother's vehicle would comply with that as well.
Well, my concern is entering multiple protection orders that have inconsistent language. That's problematic for law enforcement. It's also problematic for the courts or for the parties trying to follow these things. My thought would be is to simply have a no contact order that adopts the language of the existing protection order that was entered.
So do you want to just enter the protection order within this case?
Do what?
Do you want to enter it as a protection order in this case number? Or do you want to enter it as a restraining order in this case number?
Well, I'm not sure that there's a difference as far as the police enforcing those. It seems to me they should just be consistent.
Okay. So what you're instructing me to provide for other language in the restraining order that adopts the specific language of the protection order.
That would be my preference.
Okay. So I'll do that as an in the restraining order at paragraph 5. I'll identify it as, for example, A, I'll just say other, and then I'll adopt the language from the protection order.
Yeah, I think you just copy and paste that in there. That would be.
Sure.
I think and then the rest of that order would be fine other than that.
Okay. And I'll include paragraph 4 on the notice that Mr. Bondurant was present.
Correct.
And had notice of the hearing.
Okay. Thank you. All right. Then as far as the temporary order, do I have I guess I didn't see, and maybe I missed this, I didn't see a financial declaration from your client, so I don't know what the requested fee is, and I'm not sure what the basis on that is.
I didn't provide a financial declaration. I provided sealed financial source documents. So that outlined the delinquency in his child support and her wage stub and tax return. So if the court wants me to supplement that with a financial declaration, I can do that.
I didn't see that wage stub in there. I overlooked.
So under sealed financial health, we provided my client's wage stub from August 4th of 23 and her 2022 W-2. So in 2022, she grossed $41,616, which is, what is that, roughly $3,800 a month?
All right. Well, I think
$3,400 a month.
I think based on that, and I hadn't seen that before, but my apologies. I looked through a lot of documents. I must have missed that one. I'm going to simply, at this point, have each party pay their own fees. At this juncture, that's not a final order. That's just a temporary level based on that information.
Will the court consider reserving my client's request?
Reserving on the temporary?
Yes, reserve for my client's request for fees on temporaries at the time of trial or whenever.
Yeah, I don't have a problem with that. I'm just not going to order temporary today. So.
Okay.
And then on the we'll need a revised temporary family law order that has that.
Right.
And I think referencing the temporary parenting plan, since I think I want to defer on that over at least until we see if we need a guardian ad litem, because there's a lot of provisions that are in your parenting plan that are more than I'm inclined to go today based on what I have. Particularly since I don't know if this is going to be a default type of case or what a guardian ad litem is going to recommend once they take a look at it.
Okay, so just so I understand then, so we're going to defer on the parenting plan, we're deferring on the guardian ad litem.
Correct.
And
then I'll need a revised temporary family law order and a revised restraining order.
okay,
And we're also deferring on the default issue 1 week.
correct. So those are all over to December 5th at 9 a.m.
Correct.
Okay. And then do you want to set a presentation date, or do you want me to submit these ex parte?
Well, if they're agreed, they can be ex parte, but I can also set a presentation date if you want.
Let's go ahead and set a presentation date, but I'll submit them to Mr. Bondren. If he believes that they reflect your ruling today, then we can get them signed.
You want to do the 8th or the 15th? The 15th is probably safer, but
I'm out of state that day.
Okay.
I could. Is this at 8:45?
8th at 8:45. Yeah. And if that doesn't work, just bump it. Any Friday at 8:45 is generally fine. You may want to check with court administration because I don't know what my presentation doc looks like in January, frankly.
Okay. My preference would be the 8th at 8:45.
Okay, I'll put it on there. But like I said, if there's a problem getting it to that date, then it can be bumped to another date that works.
Your Honor, clerk, I just want to advise that your presentation is 3 of 2 at this point, so this will put it at 4. Is that okay?
I couldn't quite hear that. I'm sorry.
Sorry, I just wanted to advise that your presentation docket is at 3 of 2 at this point, so this will put it at 4 of 2. Is that okay?
That's fine.
Okay.
Your Honor, I won't be available for the month of December or I wouldn't have a job. I'd have to restart my training. So where are we at with that?
I understood that he said he worked Monday through Thursday.
What was that?
Did you not indicate that you work Monday through
No,
Thursday?
Monday through Friday, the whole month. And I can provide a schedule for the courts. If there is a day there that I can make work, then I don't start until the 5th. So
why don't we do this? There's not the orders that I've ordered are not particularly complex. So why don't we just note it on if there's a problem, and you'll have his schedule and we can, find a time to do it.
Okay. So we're not going to do December 8th.
Well, I can set December 8th, but it looks like, he's telling me right now he's unavailable to even appear that day, which is problematic. So, I could set it probably into January, but I don't think you want to wait that long. I just don't know do you know what my presentation days are in January to my clerk?
I'm looking.
I just, we've got a big change coming and I've got a new rotation, so I'm not.
What about this Friday, the 1st?
I'll be here on the 1st, I think. We can try that if you want.
I'm fine with that.
Okay, I'm gonna put it on the 1st. That's this Friday at 8:45. Are you working on Friday, sir?
I am not.
Okay, well, let's put it the 1st at 8:45. Ms. McLean will shoot you some documents and then be back on Zoom at 8:45 in the morning, and we'll chat and make sure that they say what we just talked about.
Okay, and then I need to provide that form and is that something that's just filed to the courts, or I serve it to Ms. McLean also?
Yes. Yeah, anything you file needs to go to Ms. McLean. If we do end up with a guardian ad litem, anything should also be served on the guardian ad litem. But at this point, we don't have that.
Okay.
All right, and that form is called an answer, and that's what you need to file.
Okay, perfect.
Okay.
All right,
So
8:45.
This Friday at 8:45, and then you're also going to be on the
December
5th on
at
the
9
rest of the issues. So you are going to have some other issues that you may want to, if your answer's filed, the default issue wouldn't be in place, but there will be likely some other things that come up. So what I would suggest, sir, would be to reach out to your employment let them know that you have a court hearing you have to be at, or work with Miss McLean to come up with another time that potentially could work. But I'm setting it over to next week for you to get that answer filed, then we can go from there.
Okay,
And
thank
Your
you, Your
Honor
Honor.
has signed the adequate cause order today.
I did. I signed the adequate cause, and I think that's all I signed today.
All right, so I'll submit a updated temporary family law order and a restraining order. Thank you.
Yes. Yep. And I believe that's everything on this.
Thank you.